Welcome to our deep dive into Special Immigrant Juvenile Status, or SIJS. First, we will clarify what SIJS is and who it protects. Next, we will break down the two-phase process across state and federal systems. Then, we will explore the critical catch, the decades-long visa backlog, and what that means for young people and their families. Finally, we will discuss realistic expectations while waiting, common pitfalls, and how to choose the right legal counsel. Throughout, please remember this video is general information, not legal advice. Let's begin. Here is our roadmap. First, we define SIJS in plain language. Second, we explain the two distinct legal phases, state court and federal immigration. Third, we unpack the decades-long visa backlog and how the Visa Bulletin and priority dates control timing. Fourth, we outline practical steps and risks while waiting. We share advice for selecting specialized counsel. Then, we test your knowledge with quick quizzes. Lastly, we close with key takeaways so you leave with a clear action plan. Special Immigrant Juvenile Status, or SIJS, is designed to protect certain young people when a juvenile or family court determines that reunification with one or both parents is not viable due to abuse, neglect, or abandonment, and that remaining in the United States is in the child's best interest. Importantly, SIJS is not automatically a green card. Instead, it is a status that positions the young person to eventually apply for permanent residency when a visa number becomes available. Understanding this distinction is essential before starting the process. To potentially qualify for SIJS, a juvenile or family court must issue specific findings that the child was abused, neglected, or abandoned, that reunification with one or both parents is not viable, and that it is in the child's best interest to remain in the United States. The predicate order, which contains precise legal language, is the foundation of the entire federal case. Because state age limits and jurisdictional rules differ, it is crucial to act early and work with counsel who understands both state and federal requirements. This flowchart shows the end-to-end journey. First comes the state court stage, where a juvenile or family court issues a predicate order. If the order is not issued or lacks the right findings, it needs to be corrected and refiled. Once the predicate order is in place, the federal I-360 petition is filed. During adjudication, USCIS may request more evidence or issue a notice of intent to deny, which must be addressed. If USCIS approves the I-360, SIJS status is granted, and a priority date is set. However, due to visa number limits, the applicant typically waits, often for many years, until the priority date is current, per the Visa Bulletin. Once current, the applicant can file for adjustment of status to seek a green card. At any point, if the applicant is in removal proceedings, additional defenses or relief may be necessary, because SIJS approval alone does not automatically stop those proceedings. Here is the process in steps. First, bring the appropriate case in state juvenile or family court and request the specific SIJS findings. Second, ensure the predicate order contains precise language that meets federal standards. Many initial orders are rejected because they are incomplete. Third, file Form I-360 with USCIS, attaching the court order and supporting evidence. Fourth, respond to any USCIS requests such as RFEs or NOIDs promptly and thoroughly. Fifth, if approved, you gain SIJS status and a priority date. From then on, track the Visa Bulletin to see when your date becomes current. Sixth, once a visa number is available, file the I-485 for adjustment, along with biometrics and a medical exam, and attend any required interview. Seventh, keep meticulous records. Update your address with USCIS, and stay compliant while you wait. This timeline highlights the natural order of events. First is the state court phase, where the predicate order is secured. Next is the federal I-360 filing and adjudication, culminating in SIJS approval and assignment of a priority date. Then there is the extended waiting period, due to visa number unavailability, which can last years to decades. During that period, applicants should continue with schooling and life, maintain address updates, and seek additional relief if placed in removal proceedings, since SIJS approval alone does not halt removal. Finally, once the priority date is current, the applicant files the I-485 for adjustment of status and proceeds to biometrics, any required interview, and ultimately a green card decision. Here is the critical catch. Federal law caps the number of green cards available each year for the SIJS category, producing an extremely long queue. Demand is especially high for certain countries, leading to massive backlogs. Your place in line is controlled by your priority date, which is generally the I-360 filing date. The Department of State publishes the Visa Bulletin, which dictates when a priority date becomes current. Approval of the I-360 does not mean an immediate green card. It positions you in line, and, in many cases, the wait can extend for years or longer before you may file for adjustment. While waiting, there are several realities to manage. First, SIJS approval by itself does not grant international travel permission. Traveling without the right documents can jeopardize re-entry. Second, an approved I-360 does not automatically stop removal proceedings, so if you are placed in proceedings, you will need additional defenses or relief. Third, work authorization is not automatically granted by SIJS approval. Eligibility often depends on other applications or statuses becoming available. Fourth, continue with your daily life and responsibilities, including school and community obligations. Fifth, ensure USCIS has your updated address by filing the AR-11 promptly to avoid missing critical notices. Sixth, keep organized copies of all filings, orders, and correspondence to support future steps. During extended waits, continued organization and vigilance are essential. First, maintain a secure, organized record of all filings, receipts, and court orders, ideally with backups. Next, promptly update your address with USCIS using Form AR-11 so notices are not missed. Then, track your priority date and the Visa Bulletin to stay aware of movement. If you are in removal proceedings, consult counsel about possible defenses or complementary relief. Additionally, avoid travel abroad without proper authorization because it can create serious complications. Maintain stability by staying in school and engaged in your community. Finally, revisit your legal strategy with your attorney periodically, as policies or your circumstances may change. This pie chart is illustrative and not based on specific statistics. It visually reinforces that demand is especially high for certain regions, such as Mexico and Central America, which contributes to longer waits in the SIJS visa queue. The exact proportions vary over time and by official data, so always rely on current government sources for real numbers. Comparing counsel types highlights common pitfalls. A specialist in SIJS cases knows exactly how to craft the predicate order so federal authorities accept it and understands federal policy, priority dates, and the Visa Bulletin. Such counsel anticipates RFEs or NOIDs and prepares targeted evidence, and they build a strategy for navigating the prolonged waiting period while coordinating with removal defense if necessary. In contrast, generic assistance often overlooks precise order language, misunderstands backlog mechanics, responds weakly to agency requests, and lacks an interim risk management plan. Choosing specialized counsel can prevent costly delays and denials. Before proceeding further, please note this content is for general informational purposes only and does not constitute legal advice. Immigration outcomes depend on individual facts and changing laws and policies. You should consult a qualified immigration attorney who has experience with SIJS for guidance tailored to your specific situation. Quiz time. Which statement best describes the SIJS process? Option A. It is a single federal application that immediately grants a green card. Option B. It is a two-phase process involving a state court predicate order and a federal I-360 petition. Option C. It is only about proving country conditions. Option D. It is a travel document you can use to re-enter the United States. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. SIJS is a two-phase process. First, you obtain a predicate order from a state juvenile or family court with specific findings. Then, you file the federal I-360 petition with USCIS. These are distinct steps, and both are required. Next quiz. What does approval of the I-360 actually mean? Option A. You immediately get a green card. Option B. You can travel internationally without any other documents. Option C. You are placed in a queue for a green card and must wait until your priority date is current. Option D. Removal proceedings automatically stop. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. Approval of the I-360 sets your priority date and places you in the green card queue. The actual ability to file for adjustment of status depends on when your priority date becomes current under the Visa Bulletin. Here are the key takeaways. SIJS can protect qualifying youth, but it is not the same as receiving a green card. The process is a two-step path beginning with a state court predicate order, followed by a federal I-360 petition. Because of annual visa limits, the backlog can last years or even decades, and your priority date dictates timing. SIJS approval by itself does not typically stop removal or authorize international travel. Finally, specialized counsel is crucial to prepare correct orders, avoid federal rejections, and plan for the long wait. To wrap up, focus on fundamentals. Secure a carefully drafted predicate order that meets federal SIJS standards. File a complete I-360 and respond promptly to USCIS requests. Monitor your priority date and the Visa Bulletin. Plan for the waiting period by maintaining stability, organizing records, updating your address, and consulting qualified counsel. Revisit your strategy over time as policies and your life circumstances change. Thank you for watching. If this video helped you understand SIJS and the realities of the visa backlog, please like, share, and subscribe. We would love to hear your questions or experiences in the comments so we can cover them in future videos.